Every day in the USA, people find themselves in court.
Thank you.
Can I have your name, sir?
Andrew Weber.
All right, Mr. Weber, I'm going to call your cases. My name is Judge Hesselink. I'm coming to you from the district court. You're here for arraignment. You have a number of cases, so it's going to take me a minute to kind of get through them in the beginning, and then we'll tell you what they're about. This is the matter of the state of Michigan versus Andrew Weber. First file is 23-41430-ST, set for a bench warrant arraignment. Next matter is 22-40885-ST, set for a bench warrant arraignment. Next matter is 23-41806-ST, set for a bench warrant arraignment. Next matter is 23-41671-ST, set for a bench warrant arraignment. Then we have 23-41545-ST for a bench warrant arraignment. Followed by 17-34550-ST, set for a bench warrant arraignment. And then the last of the bench warrant arraignments is 22-41083-ST. And then we have two new felony matters, 25-43921-FY and 25-43922-FY, also set for a notice of arraignment. So, Mr. Weber, my job today is to tell you what you're charged with. There are two new felony files that I'm going to talk about first, and then I believe that there are seven old failure to appear misdemeanor cases, most of them driving with license suspended, where you failed to appear, and I'm going to arraign you on those warrants in just a minute. So as to the new charges,
Sir, is the prosecutor in the room?
he is. Mr. Fortier is here with us, as well as Mr. Truce, a defense attorney.
Okay. Give my
Well, hold on. You got to let him go through the charges with you before you talk to him.
Oh, okay. I was just gonna make that a lot quicker for the driving one.
Well, I'll talk to you about all of these cases. What I'm going to do first is tell you what you're arraigned, what you're charged with on these two new felony cases. Then I'll tell you what your rights are. Then we'll address bond. And then once we're done with those two new cases, then we'll address all of the bench warrants, the 7 bench warrants on the old driving license suspended cases. And if you need to ask a question, I'll certainly hear you at that time. And we'll talk with Mr. Truce about whether or not you should ask him or you should ask me, or we should do something else. So, all right. As to the first case, which is the 43922 file, this says that on or about December 17th of 2024, in the Hayes Township of Otsego County, you commit the following 4 offenses, and they all involve the same type of offense: controlled substance delivery or manufacture of methamphetamine. Count 1 says that you did deliver the controlled substance of methamphetamine contrary to Michigan compiled laws. That's a felony offense. Has a maximum penalty of 20 years and or a $25,000 fine. Count 2 says exactly the same thing, as does count 3 and count 4. So there are 4 counts of exactly the same charge: delivery of the controlled substance methamphetamine with a 20-year and or $25,000 possible fines and costs. Do you understand the names in each of these 4 counts to be delivery or manufacture of methamphetamine?
Say that one more time, Anna.
Do you understand that the name of each of these 4 charges is controlled substance delivery or manufacture of methamphetamine? All right. And do you understand that the maximum possible penalty in each of these 4 charges is 20 years in prison and or a $25,000 fine?
Yes, Your Honor.
All right. As to each of these charges, you have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you in these cases, or in this case, and as to these charges, and you have the right to have a trial by a judge or by a jury. Mr. Truce is here to assist me in a minute to talk about your right to an attorney, but let me tell you what your rights to a trial are first. You have the right to see, hear, and question all the witnesses against you at a trial. You have the right to have the court order and get a subpoena from the court to require witnesses to appear and testify in your behalf, and you have the right to present witnesses and evidence at that trial. At a trial, you'd also have the right to testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. At trial, you'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if in the future you enter a plea, you'd be limited to asking the court for permission to appeal. Do you understand all of the rights that I've just informed you of?
Yes, Your Honor.
Do you have any questions about any of those rights?
Not at the moment, Your Honor.
All right. If you do have a question, please let me know. As to counsel then, Mr. Truce, if you had a chance to speak to Mr. Weber about that?
I have, Your Honor. He will be approved for counsel. And I'm not sure exactly how this court does it versus some of the other courts that I practice in. I don't know how the court here typically handles bench warrants. I mean, is the court going to set a contempt trial, or I guess if the court does, he'll be approved for that as well.
All right. I appreciate that. Thank you. All right. I assume, Mr. Weber, that you're going to ask for court-appointed counsel?
I kind of have to at this moment.
All right. So I will approve that request. What happens next is the approval gets sent to the administrating attorney. His name is Mr. Gilo, and he assigns the specific attorney that's going to represent you. I don't know who that is yet. So in the meantime, while that's waiting for that to happen, I'm going to enter a standing mute or a not guilty plea on your behalf in order to preserve your rights. I'm also going to set a couple of quick conference and hearing dates to also help preserve your rights. The first is called a probable cause conference. That's a chance for the lawyer and the prosecutor to talk about the case to see if there's a way to resolve it quickly. The next hearing, and that will occur within the next 7 days. Within the next 21 days, you'll also have a hearing called a preliminary examination set. And that's a hearing in district court in front of me as the judge to determine if there's a small amount of evidence called probable cause that you've committed the crimes that you're charged with. That is not a determination of guilt or innocence. It's just a determination of whether or not there's enough evidence to proceed with the case. And do you have any questions about those hearings?
No, Your Honor.
All right. What we're going to do next then is we're going to address bond, and I'm going to hear from both of the attorneys, and then I'm going to give you an opportunity to tell me what you want me to know about bond as well. So, Mr. Fortier, is there anything that you want me to know about bond?
Your Honor, although Mr. Weber doesn't have any felony convictions in his history, he does have 13 prior misdemeanor convictions. None of them are for serious misdemeanors. That's a various combination of operating while intoxicated, driving on suspended licenses, or a suspended license, and then writing several bad checks. Although he doesn't have, a serious criminal history, he's got those. He also has a history of failing to appear. As the court can see, some of the case numbers on the outstanding bench warrants for the driving cases, that goes back. I don't know if the 2017 case was addressed, but 2022 has a few, 2023 has several, and even while the cases have been with me in district court, there's been a couple failures to appear, which is how they ended up in bench warrant status for the maybe second or third time since they've been filed originally. So that's a concern. On top of that, the fact that there are 4 20-year offenses alleged in the 43922 FY, and then there's 1 10-year offense in the 43921 case. It's concerning that he's out with potentially warrants for, albeit non-serious misdemeanor cases, but they're still out there. And he's dealing methamphetamine in our community. So I would point out that that's very, very dangerous to the community at large. On top of that, there was a search warrant conducted in the home after his arrest yesterday, and 7 separate firearms were confiscated. Although there are no firearms charges yet, there is more information being sought out. So that could be something potentially coming in the future. But the fact that there were 7 separate firearms, he's dealing methamphetamine. One of the charges is maintaining a drug house, which contained those firearms. He's got meth at the property. He has a history of failing to appear. I think it's twofold, that he's danger to the community and there's a concern that he might not show back up to court. So I'm going to ask the court to take those into account when evaluating whether or not to issue this bond amount, but I am going to ask for $100,000 cash or surety. I know that seems extreme, but I think the charges are extreme and warrant an amount that high. I would also ask the court to put in the standard conditions of bond, also order that there be no consumption of alcohol or illicit controlled substances, that he participate in a substance abuse monitoring program, and that he report via community corrections.
All right, thank you. Mr. Trush, your thoughts?
Thank you, Your Honor. A few things that I would highlight for the court. I guess, the first thing I'll do is address kind of the elephant in the room. Mr. Weber has some significant health issues. The jail confirmed to me that they have confirmation of an appointment he has tomorrow, essentially regarding surgery to extract some cancerous. Well, I guess I don't want to make a presumption of what the removal is, but I think he believes at least it's a cancerous growth that's being removed that's consistent with what the jail reported to me in terms of what they were able to confirm. I generally would say I agree with the prosecutor on much of what he said. The charges here are significant. There has been some appearance issues. Mr. Weber reported to me that he did appear for court in regards to the traffic offenses. He believed that there was some kind of agreement that was worked out with the prosecutor. When he appeared, the court had told him that it was not the right day for him to be there, that he didn't have a hearing that date. He was told to call the prosecutor, and he followed up on those things. At the end of the day, I mean, he's lived essentially his whole life in this community. He's building a house in this community as we speak. He has family in the area and he has significant medical issues. I would suggest to the court that while the prosecutor's request may, in normal circumstances, make sense, I would ask the court to set a bond that he can make so that he can address some of those medical issues. And then just in regards to the comments about the firearms, again, he has no felony history, so it's certainly not illegal for him to possess them, at least at this stage. There hasn't been a suggestion that he did anything illegal with them. I guess in the abstract, could the prosecutor allege that it was, he was possessing the weapons while possessing methamphetamine and charge something that way? I don't know, but I mean, there's nothing that suggests any overtly dangerous activity with those weapons. So again, I would suggest to the court a lower than normal bond would be appropriate, taking into account Mr. Weber's unique circumstances. Thank you.
All right, Mr. Weber, you also have the right to address me with any other information that you want me to be aware of. Let me simply say this before you begin. We are recording this so that anything that you say about the facts of the underlying case could be used against you. So I would suggest that you tell me about bond issues, your ties to the community, safety, dangers to the community, all those kinds of things, but don't tell me things about the underlying facts of the case.
Right.
All right, go ahead, sir.
Right now, I was a tile setter. I've been doing one job a month to help keep us afloat. I called the prosecutor after you told me I came on the wrong day. And when I called him, he told me we already made the deal. We were going to drop all 7. The 8th one was driving without a valid license, second offense. And he asked for my number, took it down and said he would call me with the next court date. And that was about a month and a half ago. or right after you told me to get a hold of him. And I ain't going nowhere. And we're also trying to start up the Johnson's old water rigs and get going in the community. Because they need
I'm sorry,
fresh water.
I didn't understand what you just said. You're trying to do what in the community?
I got a second business I'm trying to get taken off because it's put fresh water in the community. You know,
What kind of
wells, water
kind of
wells.
water wells? Okay.
Yeah. Yeah. So I'm not going nowhere. But Dr. Olson thinks I have melanoma and it's getting real aggressive because it went from just being a bump for 15 years to all of a sudden making a 3-inch mass in my leg, and I got a 1-inch circle, coming out. And I did my first colonoscopy last Friday, and they found 4 large polyps. So I just have some doctor issues to take care of real quick. The appointments. Other than that, I can come up with a good bond.
All right. Is there anything else that you want me to consider?
Not as far as not dealing with the case, no. I mean, like I said, I have relatives that work here. I have relatives that work in the court. I'm not going nowhere. My wife's here. I just need time to get my affairs in order, Your Honor. No matter what, that's
All right. Thank you very much. I appreciate the information. The issues that I have to deal with on bond per the statute and the court rules are twofold. One is the likelihood of your reappearance, and the second one is protection of the community to make sure that nobody's going to be injured if you were to be released, and there wouldn't be any additional.
Give you my full faith, that wouldn't happen. Nothing.
Okay, Mr. Weber, this is. I gave you your chance to talk. This is my chance to talk now. So that's all right. That's why I'm telling you so that you know. But we have to kind of take turns, and this is my turn. Is there something else that you wanted to let me know?
Yeah, I also have 6 inches of gut sticking out of my stomach because I have a hernia surgery coming up. I didn't know. I told you that yet.
Nope, I hadn't heard that. All right, thank you.
Thank you. Sorry.
No, that's all right. So the two major things I need to consider are the safety of the community and your likelihood of appearance. The fact that you have, I've only been doing this in this court for 8 months now, but I did it as a tribal judge for about 2.5 years in front of that. And I've never seen anybody with 7 bench warrants for failure to appear. And years go back from starting in 2017, as the prosecutor indicated, a number in 2022 and a number in 2023. And I appreciate that you recently made an effort to try to address those things with the prosecutor's office. But that alone does not negate the fact that you've had these cases pending for so long. And so that gives me some concern as to whether or not you will appear when you're supposed to, even though you are a longstanding member of the community. In addition to that, no, sir.
Oh, okay.
I gave you your opportunity.
Will I get a chance to at the end?
No, I gave you your opportunity. This is my chance to make my decision. If you disagree with it, your lawyer will be able to appeal it or ask you.
Going to remind you about the tornado that took our house. That's what I'm saying. That's why 22 to fire.
Okay, Mr. Weber, this works in one way and one way only. I give everybody their chance to talk, and then it's my chance to talk. And so you don't get to interrupt. All right, but I've told you twice now. I'm not going to do it again.
All right.
Sorry. All right. So the next concern that I have is the seriousness of the alleged offenses. Methamphetamine is a terrible scourge on our community, and I'm not presuming that you are guilty of that offense. But when the prosecutor brings me a warrant with 4 separate charges on it, all with delivering or manufacturing methamphetamine, I have to treat that very seriously. And so the bond is going to be set in a manner that reflects that. Now, I understand your health issues that you've told me about. However, the only thing that I really have by way of documentation that substantiates your claims is a note from, or a page from Petoskey Surgeon's PC, which simply says that you have an appointment with Dr. Parsons on Thursday, August 7th at 11:30. It doesn't tell me about what. It doesn't tell me the necessity for it. It doesn't tell me the timeliness of what's needed. It doesn't tell me that it has to be done on that date. It could simply be a scheduling matter for all I know. Now, it may be as exactly what you said. I simply don't know those things, and I can't make a good bond decision based on things that I don't know. So I'm going to leave it open for your attorney to assist me in the future by coming up with some more specificity as to what specific medical needs that you have and when you need them. Now, again, Mr. Weber, I know that you want to tell me more stuff, but I'm telling you right now, I need some documentation and some confirmation, not from you.
No, I was
So
gonna
you-
say, my wife only brought you part of the paperwork. I don't know why.
Well, your attorney is going to be able to assist me in the future with that. And if there's some immediate need, we'll work something out to get you there and get you back, and we'll get it worked out. But as of today, I don't have the things that I need for today to make a rational decision about releasing you or not, because I don't know the severity and I don't know the timeliness need. If it's something that you need emergency surgery for, then yes, we'll make accommodations for that. But if it can wait for a week or 2 weeks or a month, I need to know that too, and I simply don't today. So I'm not going to address those things other than say you can bring it up to me in the future.
Well, I think you probably could wait a month if we got reinstated, but I don't know. My doctor was freaking out. That's all.
All right. Well, you'll be able to bring that before me through your attorney in the future. I'm going to set this at I'm going to set cash surety of 10% at $50,000. That means you're going to have to post $5,000 on this file up front. You will, if you are released on that, you'll have to appear for any examination or court date set by the court. You'll have to abide by any judgment of the court. You may not leave the state of Michigan without the permission of the court. You may not commit a crime while on release, and you must immediately notify the court in writing of any change of address or telephone number. You also may not use alcohol or illegal controlled substances. You must participate in a substance abuse testing or monitoring program, and that would be through the Community Corrections Program. That's the agency that monitors people who are on bond for felony cases, and you'll be given information about how to contact them upon your release from the jail. I'm also going to say I'm not going to make any finding as to whether or not it's appropriate for you to be charged with any kind of firearms, because that's not my job, but I am going to say that you are not to purchase or possess firearms or other dangerous weapons while you're on bond. So if you do have any other weapons that have not been confiscated as part of the search warrant, you must give those to somebody else so that you do not possess them while you're addressing these charges. You must report to community corrections upon your release, and there's a telephone number that you are required to call, and that'll be given to you at the jail. All right. Do you have any questions about that bond, Mr. Weber?
No, Your Honor.
Mr. Trush?
Sorry, I was
Any
muted. No,
questions?
Your Honor. Thank you.
All right. And Mr. Fortier, any questions?
Just a clarification. I don't know if I might be jumping the gun here or not, but I heard you say 50,000 cash surety, 10% on this file. Does that mean that the court's going to address the other felony file separately?
That is correct.
Okay. Thank you.
Yep. All right, Mr. Weber, the next file is the second new criminal charge, felony offenses, and then once we get done with this one, then we'll address the misdemeanor bench warrant issues. So in this particular file, which is 43921-FY-3, it says that on or about August the 5th of 2025, within Hayes Township of Otsego County, that you did commit the following 3 offenses. Count 1, it reads that you or charges you with possession of a controlled substance, methamphetamine or ecstasy, and it says that you did knowingly or intentionally possess methamphetamine contrary to Michigan compiled laws, that is a felony offense, has a maximum penalty of 10 years and or $15,000. Do you understand the name of that offense?
Yes, Your Honor.
You understand the maximum penalty for that offense?
Yes, Your Honor.
Count 2 alleges a controlled substance offense called maintaining a drug house. And it says that you did knowingly or intentionally keep or maintain a dwelling that was used for the keeping of or selling of controlled substances in violation of Article 7 of the Public Health Code. And that's contrary to the Michigan compiled laws. That is what's called a high court misdemeanor, although it's treated like a felony offense because it has a maximum penalty of 2 years and or a $25,000 fine. Do you understand the name of count 2?
Yes, Your Honor.
You understand the maximum penalty for count 2?
Yes, Your Honor.
All right, count 3 alleges a misdemeanor offense. It's called operating while license suspended, revoked, or denied. And it says that you did operate a motor vehicle upon a highway, that is Johnson Road, while your operator's license from the state of Michigan was suspended or revoked as prohibited by the compiled laws of Michigan. That's a misdemeanor offense. It has a maximum penalty of 93 days and or a $500 fine, including vehicle immobilization. Do you understand the name of count 3?
Yes, Your Honor.
You understand the maximum possible penalty of count 3?
Yes, Your Honor.
All right. As to that case, you also have the right to have enter a plea of guilty, not guilty, or standing mute, or no contest. You also have the right to be represented by an attorney in that case, and you have the right to have a trial. If you wish to have a trial, all of the same rights that I previously explained to you about a trial would apply. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to present witnesses and evidence on your behalf and to get an order from the court requiring those witnesses to appear and testify. You could testify or you could remain silent, and that silence could not be used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. And finally, you'd have the right to automatically appeal unless you entered a plea, and then you'd have to ask the court for permission to appeal. You understand all of those rights?
Yes, Your Honor.
You have any questions about any of those rights?
No, Your Honor.
All right, Mr. Trush, I assume that all of the same information applies to this case as the previous one?
Correct, Your Honor.
All right, so I'm going to enter a not guilty plea on your behalf. I'm going to approve your request for a court-appointed attorney. In this case, I'm sure that the same attorney will be representing you on both of these new criminal cases. And while we are waiting for that attorney to contact you, I'm going to set a couple of court hearings in quick order so that your rights are also protected. That would include the probable cause conference within the next 7 days for the attorneys to talk, and the preliminary examination within 21 days so that you have the right to have the prosecutor prove a small amount of evidence called probable cause that you committed the crimes that have been charged against you. All right. Then as to bond in this particular case, I'm again going to ask the attorneys if they have anything new or additional to tell me. Then I'll give you an opportunity to say anything else that you want me to know about, and then I'll decide what the bond should be in this particular case as well. So, Mr. Fortier, anything additional that you want to bring to my attention?
No, Your Honor, I would just ask that the court rely on the previously made argument.
All right. Mr. Trush, anything else that you want me to know about in this particular case?
No, Your Honor. Thank you.
All right. And Mr. Weber, is there anything that you want me to know in addition to what you've already said?
This is my turn to speak, right?
Yes.
Okay, because on the driver not suspended, it all started with me not getting my license.
We're not on the driving license suspended cases
I thought
yet.
that was the third one.
This is the second one. We're going to get to the driving license suspended cases in just a minute.
But I'll be in charge with it again on this one, right?
Nope. I'm sorry.
Oh, okay.
I'm sorry. You're correct. I
Okay.
understand what you're saying now. So go ahead.
Okay, because I got a ticket 9 months after we moved saying they saw me driving, which I wasn't, and I can prove that. And then
Okay.
I went to
Hang on,
court.
Mr. Weber, let me stop you for a minute and remind you that anything that you say about the current charges could be used against you later.
Yeah, I understand.
The prosecutor could use that against you. So I don't want you to make any statements that you might hurt you in the future to be used against you.
This was the same statement I made to you the last time we had a Zoom statement. And I've been dealing with the driver assessment people back and forth on email. And we're just clearing that up.
Okay.
But that's the reason why I couldn't get my license reinstated. It was never suspended or revoked. It was just expired.
Okay. Anything else that you want me to know?
No, that's just it. Well, because of the year 2022, the tornado, we didn't get our mail for like 9-10 months because we were living in hotels. So it's not like I wasn't trying to appear. I just didn't know when. It was pretty hectic. It's been pretty hectic. But yeah,
All right.
I'm done, sir.
Is that it?
Yeah, yes, sir.
Okay. All right. In this particular case, the charges are, while there are felony offenses attached to the charge, the charges are much less serious and much less in number than the previous case. This is a possession. The most serious one is a possession of methamphetamine charge rather than manufacturing or delivering. And the second count, while as a high court misdemeanor, is maintaining a drug house, which is a much less serious controlled substance offense. And then count 3 is simply a misdemeanor. So for those reasons, in addition to the ones I previously indicated on the record in the previous case, I'm simply going to set this at $5,000 cash surety or 10%. So you'd be able to post $500 and be released on that one. Once, or if you are released, again, the same conditions will apply, that you personally appear for any scheduled court date, that you abide by any judgment of the court, that you not leave the state of Michigan without prior permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number, that you not use any alcohol or illegal controlled substances, and that you participate in a substance abuse testing or monitoring program through community corrections. I am again going to say no possession of a firearm or other dangerous weapon, and that you contact community corrections at the number that's to be given to you at the jail within 24 hours of your release, so that you can be monitored while you're on probation or while you're on bond. Excuse me. Do you have any questions about the bond in this case, sir?
No, John.
All right, Mr. Truce, any questions?
No, Your Honor.
Mr. Fortier, anything else?
No, Your Honor. Thank you.
All right. I'm going to make myself a note, Mr. Weber, as to your medical issues, that you can bring those back up to me through your attorney in the future. So just give me a minute to make a note so I remember that.
Will I get a chance to talk to the attorney today so I can tell him what to tell my wife to get to you in case for that thing tomorrow?
You can ask Mr. Truce to assist you with that. I don't know who that next attorney is going to be yet, so I don't know who to contact about that, but I believe Mr. Truce could probably pass on a message to whoever that's going to be.
That would be great because since it's tomorrow, that's the only reason I'm asking.
Yep. So I'll ask Mr. Truce to contact Mr. Gilo's office and see if they can hurry up the appointment process and have that attorney contact you as soon as possible. But that's about all I can do right now. And once I've made my notes here, we're going to address the bench warrant arraignment. So just give me just a minute and we'll be moving on to that. All right. We now address the 7 bench warrant arraignments that I previously identified on the record. I'm going to tell you what all of the dates and times are, just so that you're aware of what those things were. And then I'll tell you what your rights are as to all of those cases, and then we'll decide what to do about all of them. So just give me a minute to kind of wade through these so that you know exactly what you're looking at here. In file 40885, 22-40885-ST, there is a bench warrant that was drafted, actually a motion or order to show cause. It says that you failed to appear on 8/1 of 22 for a notice of arraignment on a charge of driving with license suspended.
Oh, 8/1/22. Okay.
August 1st of 22. The next case, file 23.
Should I ask
Yes.
when these bench warrants were given for this now?
And they were given at different times. So this one was done on 8/1 of 22.
No.
The-
Why am I getting a bench warrant now, though? What date did I miss? That's what I'm asking.
You failed to appear on August 1st of 22, and a bench warrant was issued that same date. It's been outstanding since then.
I thought we took care of that last time. We went through all this. That's what I'm saying. The prosecutor told me that he gave me a plea.
July 8th of this year was the most recent bench warrant issued.
Well, let me find it here.
Yeah, that's what I'm talking about. I never got that court date. I talked to the prosecutor about it.
The bench warrant itself would be in the brown folder.
I don't like that.
Because I gave my number, he told me, well, he asked for my number and said he'll call me because remember when I showed up and you said you're not supposed to be here yet?
Mr. Weber, I see about 50 people a day, multiple
I
days
know.
a week. So no, I don't remember
I
that,
did.
sir. I apologize, but I know it might have been fun for you or memorable to you, but it was not to me.
Right.
Okay.
Yeah.
All right. I'm been directed to a different part of the file by the court staff, and I do see a newer bench warrant, which indicates that you failed to appear for a jury status conference on July 3rd of 2025. So that is the allegation against you at this point.
Yeah, I was not aware of the date. That's all, Your Honor.
I appreciate you bringing that to my attention. So thank you very much for doing that.
And Judge, I just want to bring this up because I think there might be a little confusion on Mr. Weber's behalf. The last time I talked to him, it was actually me personally that he spoke to. It was on May 21st of 2025. My job is not to provide him with the court dates. He should have called district court. I know when we
Correct.
discussed it, I had brought up the fact that he had mixed up court dates, but the onus is not on me to provide him with his court dates. So
Oh, no,
I don't know
I agree.
where the idea that I told him that I would call him back with his court date came from,
Because that's what he said.
but that's not what happened. So
Well, and he's also previously given me a statement that he couldn't get his mail, so that he didn't know when to appear for court, and he could have called the court no matter where he was living at and found out that too. So I understand all that, Mr. Portier, but I'm happy to let you put that on the record. So, all right, the
It was
next.
just chaotic back then.
I understand what you're saying, sir, and I just want to let you know that just because it's said in court doesn't necessarily mean that everybody is that the only thing. It's all right. Next case is,
I'm supposed to get one through the mail too?
okay, Mr. Weber, here's what we're going to do. I'm going to give you a
Okay.
chance to tell me anything that you want to tell me in just a minute. Right now, I simply need to tell you what these dates are and what the bench
Okay.
warrant arrangements are. Then I'm going to tell you what your rights are, and then I'll give you a chance to tell me whatever you want me to know. So you just got to be patient with me. All right. So in file 23-41430, the bench warrant is for failure to appear for a jury status conference on July 3rd of 2025. So it looks like there's a bunch of recent court dates set on a lot of these files, and you failed to appear for that. So that's number two, that with second file that we've dealt with here. Third file is 23-41806-ST. That also alleges a failure to appear for a jury status conference on July 3rd of 2025. Next file is file 23-41671-ST. That also alleges a failure to appear for a jury status conference on July 3rd of 2025. Next file is 23-41545-ST. That alleges a failure to appear for a jury status conference on July 3rd of 2025. Next file is file 22-41083-ST. That also alleges a failure to appear for a jury status conference on July 3rd of 2025. Finally, we have file 17-34550-ST. That also alleges, well, failure to appear for a jury status conference on July 3rd of 2025. As to each of these bench warrant arraignment files, you have the right to have a contested hearing in front of me as a judge. You do not have the right to have a trial by, a hearing in front of a jury, as these are bench warrants, failure to appear in front of the court, not an extra criminal case. You do, however, have the right to be represented by counsel. You have the right to see, hear, and question all the witnesses against you at that hearing. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You could testify or you could remain silent, and the silence could not be used against you. You'd have the right to testify yourself or to remain silent. You'd also have the right to be presumed innocent until proven guilty. The burden of proof at a bench warrant arraignment hearing would be by a preponderance of the evidence. It would not be beyond a reasonable doubt, as again, this is not a new criminal case. And finally, you'd have the right to appeal. You understand all those rights, sir?
This is for the bench warrant part, right?
This is for all of the bench warrant cases, yes.
But it's not the case itself, right?
Not the case itself, it's just the bench warrant. That is
Okay.
correct.
Okay. Yes, I understand.
Yeah. All right. As to each of these cases, I'm going to appoint the same attorney that you got in the felony cases, because it seems to make good sense to have you have an attorney represent you in all of those cases. So rather than have a set a hearing right now, I'm simply going to continue those cases until there's an appearance by counsel in the felony cases, and then we'll address all these bench warrant cases at the same time. And if you're able to reach a resolution of all these cases, you may be able to talk, or your attorney may be able to talk to the prosecutor about it. So I'm not going to go any further than setting an attorney for you on these cases. Mr. Truce, do you have any other requests for me on these cases? I'm simply going to set a $500 PR bond in each of them. There's no reason for me to do anything different given the felony level bonds we've already set.
Thank you, Your Honor. I actually was going to suggest the same to the court. So no argument there. I think a PR bond is appropriate. I do think that Mr. Gilo's office must be listening into the hearing somehow, because they messaged me and identified to me that Mr. Dick will be appointed to Mr. Weber. So I give that information both for the court and for Mr. Weber's benefit. I've already contacted him and provided him with your wife's phone number. So
I have nothing to write anything down with.
They've already sent that information about your wife to Mr. Dick, though, so he's already aware of that. If he needs any additional information, he can contact you at the jail. That's basically what Mr. Truce said. All right. Mr. Fortier, is there anything else that you would ask the court to do on these bench warrant cases?
No, Your Honor.
Mr. Truce, is there anything else that you want me to do on these bench warrant cases?
no, Your Honor.
All right. And Mr. Weber, is there anything else that you want me to do on these bench warrant cases?
I just want to tell the prosecutor I wasn't throwing him under the bus. You know, I was just relaying the last time that we had talked. You know,
That's fine. That's fine. Thank you very much.
That way.
I appreciate the good attitudes you've had throughout this hearing, sir. So, all right, that'll be all for today. Thank you very much. Your
Thank
attorney
you.
will be contacting you shortly. All right.
Thank you.
What else do we have? If you could ask the jail to take you back and then bring in Mr. Geringer?
I banged the door. There's nobody.
Yep.